Hello everyone. Today let's discuss about the origin and development of Muslim law. Muslim law is a comprehensive legal, moral, and social system rooted in Islamic teachings. It originated in 7th century CE with the revelation of Quran to Prophet Muhammad in Arabia. Islam emerged in Mecca and Medina, establishing a legal and ethical framework governing all aspects of individual and communal life. The term Sharia refers to the divine path guiding human conduct and law. Now let us dwell deeper into the origins of Muslim law. Before prophethood, Muhammad was known as Al-Amin and As-Sadiq, meaning trustworthy and truthful. He married Khadija, who provided emotional and economic support, playing a transformative role in his mission to spread Islam. The first revelation to Prophet Muhammad occurred at the age of 40 in 610 CE in the cave of Hira, beginning the Quran's revelation. The core teachings emphasized monotheism, justice, compassion, accountability, and a belief in the final judgment day. You have to know that before Islam, Arabia was filled with inequalities and it was filled with polytheism. So that is why the Islam believed in monotheism, justice, compassion, equality, and even in final judgment day. If I have to digress a little bit, the Hindu law emphasizes rebirths, reincarnation, and they believe in the concept of soul. But the Muslim law does not recognize the concept of soul as well as rebirths. It only recognizes final judgment day. When Prophet Muhammad introduced Muslim law, he faced early persecution by Quraysh. If I have to tell you, Prophet Muhammad himself belonged to Quraysh tribe. Because of his disagreements with the Quraysh tribe, some of the Muslims sought refuge in Abyssinia, which is modern day Ethiopia. The Hijrah occurred in 622 CE, which marks the foundation of first Islamic state and the Islamic calendar. In Medina, Muhammad drafted the Constitution of Medina, ensuring religious freedom and civil rights for all groups. Prophet Muhammad came up with a lot of reforms such as banning usury, protecting women and orphans, and promoting equitable charity. That is why, if you want to dwell deeper into Muslim law, you have to know the five pillars. In them, one is charity. So you should know that Islam emphasizes on charity a lot. The key diplomatic events were Treaty of Hudaybiyah, which happened in 628 C, where it established truce with the Quraysh tribe and facilitated expansion of Islam. And then it was the bloodless conquest of Mecca, which happened in 630 C. There was reconciliation and removal of idolatry from Kaaba. To know Muslim law, you have to know the Quran. So the Quran basically is the primary legal text which was revealed over a period of 23 years addressing family, trade, inheritance and criminal justice. Only a fraction of Quran contains explicit legal verses, but these are highly authoritative. You have to know that. And the next one is the Sunnah. Sunnah comprises of Prophet Muhammad's sayings, actions, tacit approvals, interpreting and applying Quranic principles. And the next one is ijtihad, meaning Independent juristic reasons used to derive rulings where primary texts are silent or ambiguous. And the next one is qiyas. Qiyas are nothing but analogical deductions, applying known rulings to new situations by analogy. The additional juristic tools were istihasan, which allowed flexibility for equitable outcomes, and urf. Urf were nothing but local customs which integrated within the principles of Islam and were not contradictory to the core principles. I will explain how qiyas and itihads are derived. So first let us go into qiyas. Qiyas are nothing but analogical deductions. For example, let us think that there was prohibition of wine as well as drugs. So the first step would be to identify the original case. The Quran prohibits wine. The next step is to identify the new case. Modern synthetic drugs which use cocaine, heroin or wine. Now identify the common illa. Does the drug cause intoxication or impairment of reasoning? So the answer is yes. The step 4 would be applying the same ruling. Since wine is prohibited due to intoxication, drugs cause intoxication too. Therefore, drugs are prohibited. This is a pure analogical reasoning. No new law is created, an existing principle is extended logically. Then the next example is for the itihad. Here, let us suppose that one wants to go forward with organ transplantation among Muslims. So, there is no explicit Quranic version about organ transplantation. No direct hadith included. So, how is the ruling derived? So, the first one is to examine general principles. The Islamic law emphasizes preservation of life, human dignity, prohibition of harm, and the step 2 would be to weigh competing considerations. Is removing an organ violation of bodily sanctity? Does saving a life outweigh this concern? And the step 3 would be to apply legal maxims. One key legal maxim is necessity renders prohibited things permissible. If transplantation saves a life and consent is given, many modern jurists would conclude that organ donation is permissible under conditions. This is nothing but itihad because no direct text exists. The ruling emerges through interpretive reasoning. Let us take up another example. Let us talk about cryptocurrency trading. There are no Quranic texts which exist regarding it. A jurist may say, use qiyas because it will compare crypto to gambling if speculative and uncertain, or compare it to trade if asset backed and transparent. If analogy is insufficient, broader itihad is used. Does it involve gharar? Does it involve riba? Does it harm public interest? Riba meant interest. So if any modern transactions like trade happen, then interest should not be leviable. And gharar meant uncertainty. So gambling is one of the things which introduces uncertainty. So all these things are prohibited under Islam. So, to give a judgment, the court will look into itihad rather than analogy to suit the modern times. Before you understand the various schools of thought, you have to understand the prophetic era, Rashidun Caliphate, Umayyad and Abbasid Caliphates. The prophetic era lasted from 610 to 632 CE. Here, Quran served as a living legal code and Muhammad acted as judge and lawgiver, resolving disputes based on spiritual and societal context. Next, it was the Rashidun Caliphate, which lasted from 632 to 661 CE. Here, the leadership passed to the first four caliphs, Abu Bakr, Umar, Uthman, Ali. See, as soon as the death of Prophet Muhammad, the question arose as to who should become his successor. The one set believed in Abu Bakr becoming the next successor, as he was the father-in-law, and the way in which he would be elected would be election. And the other sect believed that it should be Ali who should become the successor, as he was the closest blood relative. Here arose the two sects, Sunnis and Shias. The Sunnis believed in election, and the Shias believed in blood relatives or succession based on blood. The practice of ijmas also emerged, which paved way for legal interpretations. These legal interpretations were made to accommodate growth, governance, and novel societal issues. And then it was the Umayyad and Abbasid Caliphates, which lasted from 661 to 1258 CE. Here, the law became systematized into distinct schools of jurisprudence. The four major Sunni madhabs which formed were Hanafi, Maliki, Shafi, and Hanbali. The Hanafis adopted a pragmatic approach. They used qiyas and juristic reasoning. And Maliki depended on the practices of people of Medina alongside scriptures. And Shafi formalized legal theory and emphasized rigorous hadith authentication. And Hanbalis believed in conservatism and prioritized transmitted texts. The Shia jurisprudence developed separately, that is the Ithan Ashariya school and Jafari school, with distinct legal methods. You have to know that the reason why there are Sunnis and Shias is that it was only because of a political angle. There were no other considerations. It was only a political angle there. Let us look into the spread of Muslim law. As Islam expanded into Persia, India, Africa, and Spain, law adapted to legal local customs while retaining core Sharia principles. Fiqh meant jurisprudence, became the framework for interpreting legal norms in diverse socio-political contexts. Let us take surrogacy into consideration. So here, surrogacy creates three possible maternal figures. The genetic mother who gives the egg, gestational mother who carries the child in the womb, and social or intended mother. The Quranic principle states that their mothers are only those who give birth to them. Now let us see how the various schools will interpret surrogacy. Hanafi school. So here the methodology they use is they give a lot of emphasis for qiyas and extensive use of istihasan and pragmatic and social progression. The Hanafis will state commercial surrogacy is prohibited, but they may allow gestational surrogacy within marriage using the couple's gametes. This is highly controversial but always debatable. The reasoning will be lineage must remain clear. The womb creates maternal linkage. Introducing a third party womb resembles zina in effect. Potential inheritance confusion. However, because the Hanafi school allows broader juristic tools like istihasan, some modern Hanafi scholars explore limited permissibility. If sperm and ovum belong to married couple, no third party genetic input, legal parentage is fixed clearly. Now let us look into Maliki school. Here the methodology they use is rely heavily on the practice of people of Medina and strong emphasis on blocking means and protection of lineage and morality. So the likely position will be strict prohibition. The reasoning which the school may give is protecting lineage is a core objective. Surrogacy opens door to commodification of womb. Even if the intention is noble, it creates social instability. Blocking potential abuse is central Maliki reasoning. Maliki jurists are among the most conservative on reproductive technologies involving third parties. Then it is the Shafi school. Here the methodology they use is systematic legal theory, strong textualization, strict evidentiary structure, likely position, prohibition based on textual interpretation. Reasoning, as I had told you in the Quran, it is given that mother is the woman who gives birth. Therefore, gestational mother will be the legal mother. Contract cannot override divine designation of motherhood. Third party involvement disrupts fixed lineage principles. Shafi methodology resists expanded permissibility without clear textual support. Now let us look into Hanbali school. The methodological characteristics of Hanbali school are strong textual reliance, limited speculative reasoning, preference for transmitted reports. Here, the position will be prohibition and the reasoning will be motherhood defined by childbirth, surrogacy resembling mixing of lineage, strong resistance to reproductive innovation involving third parties, ethical caution over biomedical experimentation. Modern Hanbali influenced jurists generally prohibit surrogacy. Example, Saudi Arabia. There were a lot of modern developments to the growth of Muslim law. In them, one was colonial influence and codification. In 19th and 20th century, there were efforts to codify Muslim law. And that is why in India there is enactment of Sharia law. And there is an act called as Sharia Act. Islamic personal law today comprises of marriage, inheritance, divorce, custody, and it is coexisting with other civil laws. There have been emergence of Sharia compliant banking and finance norms, emphasizing risk sharing and prohibition of riba, that is interest. And there are ongoing efforts to reconcile Sharia with gender equality, human rights, modern civil norms, and reinterpretation or reform traditional rulings. If I have to talk about the Muslim law in India, there is long standing influence from historical Islamic governance in the subcontinent. The Muslim Personal Law Application Act, that is 1937, officially applies Islamic personal law to Indian Muslims. Indian courts interpret Muslim law based on Quran and Hadith texts and precedents.